call him Lisa Sakevicius. He went downstairs.
You're going to have me verify your mileage this month.
You are the same Lisa Sakevicius who's previously testified for the record?
Yes.
All right. Lisa, at my request, did you run some additional graphs on known fibers?
Yes, I did.
In other words, fibers that came from the robe, which is Exhibit 88?
Yes, I did.
All right. That microphone's not coming. You did run some additional graphs from known fibers from Exhibit 88, the robe?
Yes, I did.
All right. Now, first of all, let me show you State's Exhibit 93 again. It's been introduced to State's Exhibit 93. And is that the graph that you previously testified about where you indicated that the was part of the basis of your opinion that the fibers were microscopically similar?
Yes, this is it.
All right. I think it was yesterday, Charles Lynch testified that, in his opinion, that showed that they were dissimilar.
I disagree.
All right. Now, at my request, did you take two known fibers from the robe, and run a graph?
Yes, I did.
I want to show you State's Exhibit 126 and ask if you can identify that.
Yes, this is the graph I ran. These are two separate fibers from the same robe. It shows that you can see differences between two known fibers.
All right. And about that, tell us about what differences you would have in the same garment, the fibers in the same garment, what types of differences you might have.
You might have slight color variations or slight diameter variations. This garment is composed of viscose rayon, which is a multi-lobed or cloud-looking cross-section that might vary along the length of the fiber or from between different fibers. And these could all introduce small variations in the spectra.
And is that what you were doing in State's Exhibit 126, doing two known fibers and showing a similar type pattern as to State's Exhibit 93?
That's correct.
Your Honor, we would offer State's Exhibit 126. Just to make sure this is clear, when you say on the State's Exhibit 126, two separate fibers from same standard, we talking about two separate fibers from Exhibit 88?
Correct.
Your Honor, we would offer State's Exhibit 126 and ask permission to exhibit to the jury.
No objection. All right, it may be received without objection, and you may exhibit to the jury.
I'm going to also re-exhibit to the jury State's Exhibit 93.
All right.
Now, I'd like to show you what is part of State's Exhibit 125, which is a graph that Mr. Lynch did, and ask, at my request, if you, see how can I phrase this, did I fax you a copy of that graph?
Yes.
All right. And did you examine it?
Yes, I did.
All right. And at my request, did you take another 2 fibers from State's Exhibit 88, the robe, and do an additional graph on those 2 fibers?
Yes, I did.
All right. Now, if you notice on Mr. Lynch's graph, which he shows that those 2 fibers come from a different source, he's got X's marked where a couple of intersecting points are near the top. Do you notice that?
Yes, I see that.
All right. If you would, you would take this pink marker on what I've marked for identification purposes as State's Exhibit 127, and if you would mark on the graph the similar points of intersection on State's Exhibit 127. All right. And so this will be clear. It says 2 separate fibers from the same standard. Again, we're talking about 2 known fibers from State's Exhibit 88, this row.
That's correct.
All right. Now we would offer State's Exhibit 127. When did you run those graphs?
Yesterday.
Now, we would offer State's Exhibit 127.
All right, it may be received without objection.
In running this particular graph, what, if anything, did you do to the fibers to try to duplicate the known fiber and the question fiber?
I left one fiber in its original state. The other fiber I took and I flattened it.
Okay. Now, Your Honor, may Mrs. Sakevicius step down?
Yes.
All right, now, Ms. Sakevicius, if you could show your graph, State's Exhibit 127, I'm going to show part of State's Exhibit 125, which is the graph by Mr. Lynch, where he said that they were dissimilar. Now, the fibers on State's Exhibit 127, those are from the same, they're from that row, both of them, right?
Yes, they are.
All right. And Mr. Lynch ran the known fiber and the question fiber.
That's correct.
All right. And are the points of intersection approximately the same on both graphs?
They look that too.
You can retain the
You offered it and I received it.
And once again, Mr. Sakevicius, what is your opinion in regard to what is your opinion as a result of your comparisons of the question fiber found on the black and white shirt, polka dot shirt, and the fibers from State's Exhibit 88?
That they are similar and could have a common source.
Okay.
I'm good for the question.
Mr. Sakevicius, you said something about viscose rayon.
Yes.
Is there another process to make rayon?
As far as I know, there are probably several processes.
Okay. Do you know the 2 major processes, how they make rayon?
I'm not familiar with both of them.
Okay, you know about viscose rayon.
Yes, I do.
Do you know about cupronium rayon?
I've read about it. I don't know that much about it.
You don't know that much about it, do you?
No.
And isn't it true that now it is that textbooks on fibers and fiber identification say that it is important to distinguish between viscose rayon and cupronium rayon because they are made in different ways?
As far as I know, this is viscose rayon.
The robe.
Yes.
The robe is viscose rayon. Is that right?
Both fibers are viscose rayon.
Now, you're telling us that they're both viscose rayon.
Correct.
You know that for sure.
This is what I feel, my opinion.
Is it your opinion or do you know for sure?
It's my opinion.
Did you run a GC mass spec on the question fiber?
No, I did not.
Isn't it true that a GC mass spec, that's a test that you run to determine whether or not the rayon is cupronium or viscose? Isn't that what that process does?
I don't know if it would do that or not.
So you don't even know that there's a way you don't even know that there's a test called GC mass spec that you can run to determine whether it is rayon that is viscose or cupronium.
I'm familiar with a GC mass spec. This is an instrument mainly used by drug analysts. It's not an instrument that's commonly used in fiber analysis in our field.
Okay. That test and that machine, or whatever you will call it, that process can tell you whether it's cupronium rayon or viscose rayon, can't it?
I don't know.
You don't even know that? Okay. Now, the question fiber, which I've introduced as Baldwin's exhibit number 1, I assume you've taken that back with you to the lab.
The question fiber?
Mhm.
No, I haven't.
So all these new graphs you ran, they're not on the question fiber, are they?
No, they're on the standard.
Okay. Let me make sure something again. That question fiber, is that the whole thing you found?
Yes.
That's the whole thing?
Yes.
And you flattened part of it?
It may all be flattened.
Well, did you look at it under the microscope after you flattened it?
Yes, I took a photograph of it after I
Is it
flattened
all
it.
flat or partially flat?
I believe it's nearly all flat, yes.
Nearly all flat.
My photograph doesn't show the entire fiber. It only shows about half of it.
And does it show the unflattened end or the flattened end?
I think it's the flattened end.
Okay. So you didn't take a photograph of the other end that's non-flattened?
It's hard to get the whole thing in the photograph.
Well, you can move your slide down in the microscope and take a picture of the unflattened end, can't you?
I just took one photograph. I was trying to show the color.
That's not my question. You can move the slide in your microscope to where you could take a picture of both ends.
Yes,
one
I
that's
could.
flattened and one that's unflattened.
Yes, I could.
And you didn't do that, though. You just
No.
took one of the flattened end.
No, I didn't.
Okay. How did you flatten it?
I used a scalpel,
And you just, what was the fiber laying on?
a glass slide.
And you pressed with a scalpel. Now that's sort of like that's a knife, really. Knife, sort of like a
It's like-
precision knife blade.
Yes, like a surgeon would use.
Okay, and you just press on part of that fiber on a glass slide, and then you seal it with a top, that little liquid that sets up, right?
Right.
Okay. And did you push very hard?
I don't remember how hard I pushed.
Or did you just sort of barely push on it?
I don't remember how hard I pushed.
How did you flatten these fibers yesterday?
The same way.
Same way. So you're able to take fibers off this robe and just press on them with a scalpel and flatten them, and Charles Lynch can't get them to flatten with a hammer. Is that what you're saying?
I don't know what his problem was.
Okay. If he testified that he couldn't get it to flatten with a hammer, he couldn't get it to flatten with a scalpel, he couldn't get it to flatten by pressing 2 glass slides, that he was only able to flatten it with putting 2,000 pounds of pressure on it, what you're saying is he's not as good as you are.
Yes.
Okay. You're saying you're better than he is.
I was able to flatten the fibers with a scalpel, and I found it a very simple procedure.
Okay. And so Charlie's incompetent. Is that what you're telling
I'm
us?
not going to say that.
Are you saying he's incompetent and he doesn't know what he's talking about?
I've never met the man.
Do you have any reason to tell this jury that he's incompetent and he doesn't know what he's talking about?
I would suspect somebody who couldn't flatten a fiber with a scalpel.
Okay, so you think he's incompetent?
I'm not going to go that far and say that.
Okay.
But you're suggesting that since he can't flatten a fiber, he must not be as qualified as you are. Is that what you're saying?
I'm not going to say that either.
And how long have you been working, doing this fiber work?
About 3 years.
Tell me, what kind of microspectrometer you have?
Microspectrophotometer.
Yeah, that.
It's a Zeiss UAMS 50.
Okay, and how old is it?
It's about 2 years old.
Is it important? Is it important that when you run graphs for these fibers, that the lines be parallel in order to say that they're a match?
They need to follow the same general curves and have the same peaks and valleys.
Had the same peaks and valleys and fall. And so if they intersect, they're not following the same track and with the same peaks and valleys, because if they do, they won't intersect. Is that right?
You can get two fibers from a known source to intersect.
That's not my question. When you're comparing them, if they follow the same parallel course, they're not going to intersect, are they?
They shouldn't.
Okay. All of these graphs intersect, don't they?
Yes.
Your graphs, Charlie's graphs, they all intersect.
Even the graphs of the known fibers intersect. You have to take into account the entire graph. The endpoints are not as important.
Okay. So let me see if you would agree with me on this. That let's assume Mr. Lynch is a qualified and competent fiber analyst, and you're a qualified, competent fiber analyst, and y'all look at the same things and disagree. Doesn't that really leave us with a bottom line that these really don't mean that much at all?
I can't place the meaning on this. That's not my job.
Thank you. Pastor?
Do you have anything? Thank you, Lisa. You're free to go.
Call John Gilbert. Call John Kelin.
You finish in 20 minutes?
I think so.
Yes, sir, I do. Have a seat.
Could you state your name and occupation for the jury?
My name is Scott Kelin. I'm the manager of the Blue Beacon Truck Wash that the bodies were found behind.
Okay. Mr. Kelin, at the present time and on May the 5th, 1993, what were the hours of operation of Blue Beacon?
Blue Beacon is open 24 hours a day, except for Thanksgiving, Christmas, and New Year we do close.
All right. Now, how many employees are on duty at any given time?
Between 8 and 10.
And is that 24 hours also, or is that?
No, during the midnight to 8 shift, we only have 2 employees on at that time.
All right. But up until midnight, you have 8 to 10?
Normally, yes.
All right. And do truckers wash their own trucks, or who washes the trucks?
We do all the service for them.
What are the lighting conditions around the Blue Beacon?
We have some lights supplied by the city. We have other lights that we now rent from them, which are 400-watt floodlights. And in fact, since this incident, we have added
Let's talk about at the time.
At the time, we had, I believe we had 2 of them on the west side of the building, 1, maybe 2 in back, and 4 in the front.
I don't have any questions. Just a minute, Mr. Kelly.
There'll be a map for you to look at it. Okay.
Sure.
step down, please, sir? Show the jury, and you can put a little, if you would, take this blue marker and circle the business that you manage. All right. Okay. Now, that's fine. Thank you. Now, if you would, at the May 5th, would you put a little small X or dot each place you had a floodlight? You want to do a little bigger than that because we can't see that. Okay. Okay.
The best of my memory, that's...
Okay, thanks. That's very helpful. Now, on May the 5th, was there a fence to separate your parking lot from the woods?
No, there's not.
No fence. So, if this was the drive-through, is that right? Is that fair? Of where the drive-through was? Sure. There was no fence from here to here.
No, there was not.
Thank you. You can retake the thing. Were you working the night of May the 5th?
Depending on what you mean by night, I was there. Well, actually,
What time did you go home?
that night I left around my normal time of 5 or 6, although I did have to come back to do some equipment maintenance.
And what time did you come back?
7,
Okay. And what time did you leave?
between 9 and 10.
Okay. How many employees did you have there that night between 12 and 8?
2.
Okay. And do you have any records of how many vehicles or trucks were washed that night between those hours?
Yes, I do.
And do you know how many were washed that night?
If I don't have the information with me, I could find out. I do not know at this time.
Okay. And how many of the employees does it take to wash one of the trucks? Take both of them?
It would take both of them, yes.
Okay. So if a truck's being washed between 12 o'clock and midnight, at 12 o'clock at midnight and sunrise the following morning, both employees would be inside washing the trucks.
That's correct.
Okay. Do y'all have a security guard?
No,
Okay.
not right now.
No one's out there patrolling the premises to see if there's anybody else up there.
No, there's not.
Okay. Haslett.
No question? No, nothing further.
You're free to go. Thank you.
Thank you.
Yeah, I've got one more, but I think it'll take more than...
Let's take a lunch break. All right, ladies and gentlemen, with the usual admonition not to discuss the case, you may stand at recess until 1 o'clock.
Reserve the right to, we do want to reserve the right to reopen if this test comes back.
All right.
We do want to reserve the right to reopen if this test comes back in the morning, since we won't be doing anything else this afternoon.
Okay.
So are we done? We're not going to close this afternoon?
Well, no, he's got
Are we on record, Bart?
yeah. He indicated to you Monday or whenever it was that Friday that there was a laboratory report that they were waiting to get back. So I'm going to wait until in the morning to read the instructions. We'll go over the instructions and hash those out and do whatever else we need to do. Y'all got anything else to do?
Hey, do y'all have any server rebuttal? Do y'all have any server rebuttal? Oh, okay.
Any reason we can't call the jury in?
Call them in and tell them we got, well, that's right, they got.
Yeah, they might have.
What I'd suggest is tell them that you got matters to take up to lawyers outside the prison, outside, when they can go home.
I think that applies to y'all real good.
We do need to go over the jury instructions one by one before we leave.
That's fine.
Thank you. I don't think.
Did you get that deal worked out for us?
Yes, sir.
What time?
Whenever you get
Well, just after we finish up here, I'll just meet you out the jail.
always stay here.
Okay. Well,
How far is it from Powder?
yeah, there's that slide up there too, don't?
When I called Lisa back up to the stand, I heard one of the jurors say something like, not more than this 5 or stuff.
May have been an echo, because I think I said that too.
Call renew. Previously made motion for directed verdict. Now that all evidence has been presented in the case for the previous reasons stated, Your Honor.
Judge, we'd also like to do the same thing on behalf of Mr. Echols. Now that the entire case is over with, we'd like to renew our motions for directed verdict for lack of sufficiency of the evidence.
And both motions will be denied for the same reasons previously stated. The court's of the opinion that a jury question has been formed.
And, Your Honor, I would like the record to reflect that we had previously notified the defense in regard to this potential new evidence, and that we have asked to have the opportunity, if it comes back positive.
You'll be permitted to reopen tomorrow morning for that purpose if it develops.
Your Honor, we have not argued anything regarding that, and we may have an argument if it comes back, but we've not made any objection. But if
Sure,
it
I'll
does,
let you argue, but my inclination would be that that's discretionary with the court. And
that new evidence would only go to
Yeah, I understand that. Okay? All right, I'm going to call the jury back in, and we'll go over jury instructions for the rest of the afternoon. All right, call them back in. Both sides have now rested their case. The court has heard the customary motions and made rulings on those. I do need some time to go over with the lawyers the instructions because they may, depending upon what we do, be complicated. They may be rather simple, but in any event, it's going to take us some time to hash those out. There is also a slim possibility that an additional witness would be called in the morning that would take maybe an hour the most. But in any event, I suspect that the court will be prepared to read the instructions of law to you in the morning, and that will commence with the final arguments of the lawyers in the morning. So again, with the customary and usual admonition that you are not to discuss this case with anyone or attempt to find anything out about the case, you're free to go until in the morning at 9:30. You might also let the folks at home know that tomorrow night may be rather late. We'll work at least until a reasonable period of time tomorrow evening if necessary. And then, of course, we'll have the balance of the week to finish it as well. So, but just let your home folks know that there'll be leftovers and they can warm it up or whatever. So you're free to go until in the morning at 9:30. The court will be in recess until in the morning at 9:30. If any of you are just dying to see what we're going to do, you're welcome to stay. But otherwise, court's going to be in recess. You want this?
I was going to pay you compliment.
Have you got some specific questions on AMCI that you're questioning, the wording or
No,
something?
I just like to go through and make sure I haven't forgotten them, because I don't have them committed to memory.
Well, I do.
New AMCI instructions, or?
Those are the ones that go to the bifurcation.
Right.
And of course, capital murder case is excluded from the bifurcation because it is a
It's
bifurcation.
bifurcated, its instructions are. One thing, Your Honor, it may just be an old habit, but I always liked them, each instruction to be on its own page. 101 to be on its own page, 103 to be on its own page, 104. See, then they go from 104 to 107, but then they offer on a separate page 105 and 106. I kind of like to have each instruction offered, on one page at a time.
As far as Jason Baldwin is concerned.
That's correct.
All right. And you have to request it, because if you don't request it, it could
I
be
understand.
considered a comment on the
I
evidence
understand.
for a comment on the failure for the defendant to take the stand.
I understand. We do request that it be given, Your Honor. I know we're going to. Yeah, let's just wait.
Let's bring this back.
Did you get the book, Rob?
Did you have something else?
Well, we just the instructions.
Okay, well, you don't have any questions on 101 through 110, do you?
Circumstantial evidence.
I'm going to give them whether you do or not.
101, no, that's fine. 101 to 110, that's great. That's all the usual,
Okay.
up to reasonable doubt.
Okay, I'm also going to give 105, which is expert testimony.
Right.
That's what I think.
106.
I'm giving 106, which we didn't give in the other case and should have. Circumstantial evidence. I'm giving all of them, 101 through 111. Okay. You have any reason why they can't take them back?
Oh, no, we're done.
No, we're through with what we
They
were.
want to talk to Jason.
You want to talk to Jason before they take them back?
Yeah, but Judge, there's a matter we need to make a record on with him here before he leaves, if we could.
Well, let's do it.
Well, I'm going to wait till Paul gets back. We're going to make this.
Well, I know what they're doing, and maybe we want to have Damien
Well, just
here,
to ask
too.
if they're satisfied with counsel's representation, is that what it is?
No.
Judge, it goes to our position on submission of lesser included, is what it goes to.
Yeah.
Was the state asking for lesser included?
I think so. Can we, yeah.
Well, let's call them, both the defendants back in here, and let's get on the
Jason's
record then. Well, where's,
He's in the back there. Chambers outside the presence of the press.
well, they just raised Cain. I don't see what difference it makes.
It made a difference yesterday, Judge.
Well, that was a different subject matter, and it was required to be in camera. This is not.
Okay, here, Jason.
Turn the lights off,
Yeah.
Have them kill him as far as the press room. Maybe?
I can't control the press room.
All right, these are off.
Your Honor, Jason here is standing at the bench in front of the court, and we want to inquire in front of the court on the record from Jason. Jason, we have previously discussed with you. Yeah, this is simply for the purpose of instructions, Your Honor. Have we discussed with you what is meant by lesser included offenses?
Yes, sir.
And that lesser included, that you are charged with capital murder?
Yes, sir.
And that includes lesser included offenses of first-degree murder and second-degree murder? And you understand that you have a right to have the jury instructed on those. You could, in the court's discretion, he could decide to instruct the jury as to those lesser included offenses of first-degree murder and second-degree murder if we requested it.
You understand that? Are you asking that the court instruct the jury only on capital murder?
You want to be heard on that?
We request this. Yeah. Your Honor, we are requesting the lesser included to first and
All
second.
right, I'm going to give the lesser included instructions of first-degree murder and second-degree murder.
Judge, I'd like to make an argument.
Are you making a similar motion?
Yes, sir. We'll make a similar motion on behalf of my client. Damien, can you come here? Just report from this one.
All right.
Judge, on behalf of Mr. Echols, we have discussed with him we've got all the jury instructions on several occasions, and we've talked to you about advantages and disadvantages, and there's no good answer one way or the other, but after discussions with it, is it your opinion to only give the capital murder jury instructions on all three of the victims, and not specifically not to give lesser included of first degree or second degree? Right. Okay. Judge,
Did anybody force you or anything to make that decision? You made that in your own free will?
and we've actually been talking about this for a while now. Judge, the only citation I'd like to quote, where the defendant denies an act at all, there's no rational basis for a lesser included offense instruction. Dolby versus State, 290 Art 408, 720 Southwest 2nd, 694, a 1986 case.
Also Flurry v. State and Fry v. State.
You know, even likewise, the state is charged with capital murder, not with first degree murder and not with second degree murder. Typically, the lesser included offenses are given at the request of the defendant, not of the state law. The state law is always to request that they give these lesser included offenses, and we would like to be able to argue to the jury that the state office always not believe they approve the charges of capital murder because they are requesting that you consider first degree murder, which is a burden that is less burden on them, and that they don't even believe they can make the burden of proof of the charge.
Well, that'd be an impermissible argument. The court would not allow such an argument. That would be totally and completely improper. What is the state's position?
The state's position is that it was a case here in Jonesboro, I don't remember the name, but
One of them is Ross Allen Milburn versus the state, where it was reversible error for the court not to give the lesser included instructions when requested by the state and over the objection of the defendant. It's a 1978 case, I believe, maybe a little earlier than that. There were two of them, so it was the first Ross Allen Milburn case.
Your Honor, on another vein while we're up here, the state would move in limine at this time prior to closing arguments for the court to instruct defense counsel for both sides not to argue in relation to Inspector Gitchell saying that the case was an 11 on a scale of 1 to 10. There's no evidence in the record that he made that statement, so they would be arguing matters outside the record. Mr. Ford stated used that reference in his opening statement. There's been no proof in the record in regard to that statement, and so we request an instruction of the court that in limine that Mr. Ford or Mr. Wadling or Mr. Davidson or Mr. Price argue that statement.
All counsel, state and defense, will be limited to any reasonable inference that can be made based upon the testimony received in evidence, and any argument based upon testimony not in the record will be improper, and you're cautioned against making such argument.
Your Honor, we're asking...
I don't think I ruled on the issue. I might have, but the court feels that the evidence in this case would justify and warrant an instruction of capital murder, first-degree murder, and second-degree murder. And therefore, if the state's requesting it, then I will give those instructions. All right.
Your Honor, we
So
are
noted.
asking specifically in relation to that particular statement, since Mr. Ford mentioned it in his opening statement.
Okay.
That's fine.
Well, I'm warning you that you're to confine your arguments to any reasonable inferences that can be raised or drawn from the evidence adduced in the trial. Well, I understand that.
We were hoping you would ask. You showed much more strength than we expected.
And we were glad he didn't. You see that?
Well, any reason to keep them here further? Do you want me to ask them about their satisfaction with your representation for the record? All right, Mr. Baldwin and Mr. Echols, I need to stand and let me address a couple of questions to you. Each of you have been appointed two public defenders or two attorneys to represent you free of charge to you. Are you satisfied, each of you, as to their representation, the arguments they've made, and the efforts that they've put forward in the cases in your behalf at this point? Mr. Echols, are you satisfied?
Yes, sir.
Mr. Baldwin?
Yes, sir.
Do you have any complaint or criticism that you want to voice at this time whatsoever?
No, sir.
All right. You may escort them back to custody. All right, gentlemen. The court's going to give AMCI 101 through 111, and the record should reflect that 111 was specifically requested. Unless you've got any objections to those, I'm ready to proceed to the next instruction.
When you say 111, Judge, you mean issue
That's the no inference is to be drawn from the defendant's failure to take the stand.
You ready? We stopped it.
They're welcome to put them.
We'll print them up that way, but I just like them on.
Oh yeah, I don't care if they're printed on one page each, if somebody gives them to me that way.
That'd be fine.
I also don't have any problem giving them the way that they're tendered here, where they're collective. It makes more sense and easier to read, but... All right, I'm down to AMCI 401, the definition of accomplice and joint responsibility, and it seems to be appropriate and track the statute to me.
Judge, what about AMCI 202?
202, if I skipped it, that'll be given too. I believe that's the one on prior inconsistent statements.
Yes.
We would like that.
Well, I'm going to give it.
Yeah.
Now, it doesn't mention the lawyers.
Good.
That's not in
Oh, y'all were asking me. I've got mine right here.
That's what I could find.
This is the library.
Judge, 102 needs to be given. It's not in that standard sheet. Y'all gonna...
What is 102?
Yeah, we need 102.
Two or more defendants tried separately.
All right, somebody prepare that too.
We got them.
Okay, just a minute.
I indicated I was going to give all of them, which included 102, but I don't have it
We'll
either.
give 101 through 111.
Right.
Okay.
Okay, we're going to give 202. All right, I'm giving 401. AMCI 401 is drafted.
Your Honor, this means the accomplice.
That's not.
But we object.
Your Honor, we would object to that. We'd say there's been absolutely no testimony as to any accomplice activity at all. There has been no testimony at all regarding anybody acting as an accomplice for anybody else.
Your Honor, before we get to that, we are going to request AMCI 203, evidence that a witness has previously been convicted of a crime may be considered for the purpose of judging the credibility of the witness because of the convictions of Michael Carson.
Okay, fix it.
Okay. No, I didn't bring them. But I don't think, no, they're home. Well, I'm kind of caught off guard like the state was Monday. Thought we'd be here longer, but
The new book has been published now.
you're
AMC.
AMC, with respect to AMCI 401, on behalf of Jason Baldwin, we would object to the giving of that instruction. Your Honor, there's been no testimony whatsoever of any actions together. None. Not one witness has even put them together on that day, May the 5th. Not one witness.
Your Honor, the evidence has been that, circumstantial evidence has been from which the jury could draw the inference that there were multiple perpetrators of the crime. And Your Honor, we submit that that justifies an accomplice instruction. Anytime they act, two or more people act in concert in the commission of a crime, they're accomplices.
Your Honor, also in that light, there's a statement of Michael Carson, also the statement of the girls at the ballpark, that they both made statements admitting committing it.
Wait.
And I think logical inference is
that when they both make the statements admitting commission of the crime, then it didn't occur at two separate time periods when they were separate and apart. I think we can logically argue that they were both together and acted in concert when the crime was committed.
Your Honor, this court has given multiple instructions regarding must consider the evidence separately. This witness's testimony can only be considered against Damien. This witness's testimony can only be considered against Jason. You've allowed us in voir dire and opening statements to talk about two separate trials, and there is no evidence of any accomplice liability.
Even if they were tried separately, this would be an appropriate instruction under the circumstances of the case, inasmuch as you've got, one, what we've been characterizing as a jailhouse confession, and two, the two girls' testimony indicating a confession or admission on the part of Mr. Echols. When you take those acts, while you view them separately, while you take them collectively, a reasonable inference and argument could be made that they were on a joint mission and that they were accomplices each of the other. And I'll give 401 over the objection of both defendants.
Well, Judge, but 401, it's my understanding 401 is if it's agreed that if it's not a dispute that they were accomplices. In 402?
There's a 402 is undisputed status.
Well, that's when they're
that's when they testify.
Okay.
It's not appropriate in this case.
Is 401 the one where
Right.
it's disputed?
401 is the generic accomplice instruction where it doesn't matter whether there's testimony of...
401 is the appropriate one if I give it at all, and I think from the circumstances of the facts is adduced that it's appropriate.
So does that mean that the state can argue that evidence against evidence against Damien Echols applies to Jason Baldwin, and that he can be convicted on statements and acts of Damien Echols?
No, that's not what I said. I said when you take the two separately, that to make any sense out of it, it would have to be logical that the murders occurred, first of all, simultaneously and at the same time, at the same location, and inasmuch as you have a statement attributed to each of the defendants, that it's reasonable to assume that they were accomplices each of the other.
But this instruction states that the actions of one party are imputed to the other, and that Jason Baldwin can sit over in that chair and be convicted based on what was done totally by Damien Echols.
Only if the jury finds that they aided or directly participated in the offense with the purpose of facilitating, aiding or agreeing to aid or attempting to aid the other person in the planning or committing of the offense. It's rather clear.
Judge,
There's no evidence in the record on any one of those factors.
That's something you'll be permitted to argue.
Judge, I've got 2 points to make. Number one, I raise this accomplice instructions as another basis for our objection to the cases being severed, because if the cases had been severed, the statement of Jason Baldwin, the jailhouse snitch, would not have been admissible at the trial of Mr. Echols, and that they would not be able to prove anything
Well, I
about
think you can
accomplice.
clearly argue to the jury that the confessions in and of themselves apply only to the particular defendant. But when
my argument, Judge, I'd like to go ahead and make it, is that if the court would have granted a severance, then we would have even had the testimony of the jailhouse snitch of Mr. Carson.
you would still had a 401 argument given. If they weren't charged
alone. Was a
alone.
401 instruction given in the trial of Jesse and Miss Kelin?
Yes, it was.
But Judge, besides 401, we also, the court either has to give 402 that the accomplice is undisputed, or 403 the accomplice status is in dispute, and there's still the corroboration requirement.
Fix me a 403.
403.
Your Honor, that only applies when an accomplice testifies.
Well, Damien got up there.
Against the other one.
No, it says this instruction should be given when the alleged accomplice has testified and the sufficiency of the corroborating evidence presents an issue of fact for the jury. And that's exactly what we have.
No.
And it doesn't say anything about meaning when one testifies against the other. It's talking about corroborating evidence.
What do you corroborate if you're not corroborating his testimony against the other?
Well, you can fix a 403 for consideration, but I don't think it's applicable. But anyway, fix it and we'll take a look at it. That brings us down to 301, 302, 1501, 1502, and 1503.
Your Honor, where is this? Y'all got my packet down there, don't you? There's a 500.
It's right up there.
Y'all have a packet that I left down there on that end?
Yeah, I've got that, but we don't have the ones that we have. Annie, you know that little brown bag, that brown paper file with the battery machine? It's in there.
Your Honor, we would previously, as previously stated, we would object to the giving of the lesser included offenses and thus object to 301, 302, 1502, 302, and 1503. We feel that the only instruction should be 1501, which is the,
Well,
I believe that's the number on the capital murder.
I've already ruled on that, and it's the court's belief that the facts as adduced from the testimony at trial, it would be appropriate for the court to instruct upon the offenses of capital murder, first degree, and second degree murder. And whether I do it all on the same page or whether you have them separate doesn't really matter to me, as long as you got the transitions in there. AMCI 1507 is premeditation and deliberation. I'm going to give it unless you don't want it.
No, we have no objection to that instruction, really.
8101 is proper.
Okay.
As far
Judge,
as
that number's incorrect. That came out of the last trial.
801, isn't it?
It's not 8101. I don't know what it is, but it is an appropriate instruction. We need to correct the number on it to get, I think it's...
Which one is this?
It's the one about if you find guilty of one or more counts of capital murder, first degree, second degree murder, so indicated on the verdict form given to you.
Are y'all objecting to that?
Well, I think
No, I'm
that's,
just asking what the number was.
I'm not sure what the number is,
Number's
but
not right on there.
I don't think it is either.
Your Honor, we would,
6002 is a bifurcated, and they're not to consider punishment.
that's correct.
And that's basically it.
And the 6003.
You want to look at the verdict form?
Yeah.
Your Honor, the verdict forms, I will have them retyped and proffered. We would like them to be per count
all right.
in charge, and we would like for them to have one verdict form for each young
defendant?
boy,
I mean,
or for
each
boy,
victim? That's
for
all right.
Michael Moore, for either.
For each defendant also.
Yes,
That's
so
all
there
right.
would be 6 verdict forms, and that we would prepare them to where each one we find.
There'll be 6 verdict forms for each of 3 charges. There'll be 18 verdict forms.
No, so there would be 3 for Jason. In other words, they would have 4 places where they could mark. They could either find him guilty of capital, guilty of first, guilty of second on Michael Moore, or not guilty on Michael Moore. That'd be 1 form.
That's all right. I'll do it that
And
way.
then Stevie Branch, capital, first, second, not guilty.
That's all right.
Y'all follow what I'm saying?
Yeah. Yeah, that's fine. Fix
All
them.
right, we'll prepare those in, Judge.
Anything else?
Let me make sure I've got the numbers then. We're going to give 101 through 111, all through that, right?
All of them.
Okay.
Judge, one thing, if Mr. Ford's going to do that on those pertaining to his client, then if he could also prepare similar verdict forms for somebody. 'cause
I'll do them
got-
all. I'll do them.
Okay.
That way they're all they're on the same printer. I'd be happy
You
to.
gonna do it for us too?
I'll do them too.
all
I'll
right.
be fine.
And we could get copies of all of those too.
We'll get it done this afternoon before they go home. Then we're going to give, what was it, 202?
I think there's 102 is the one we got 2 or 1 defendant.
102 is the one you don't have, but that's where there's 2 or more defendants charged jointly, and that should be given.
Okay. Then we're going to go to 202.
202 and 203.
203.
Then you're actually going to have a 301, a 302,
301, 302, then it's 1501.
a 401, and a 1501, 1502, and 1503.
Your Honor, the accomplice instruction ought to come before the,
I'll read it before I
Before you
read.
start reading the 300s and the 15s
Yes.
together, you're supposed to do that.
And the 301s and 302s are all combined in there with the...
I think the way you've got it's fine
That's-
here, frankly.
Yeah, I like the way that's done. That's done.
The only thing you really need to change is those first 101 through 111, and the number on what we've got is 8101. Any reason to keep Barbara here?
No, sir.
Okay, Barb. See you tomorrow.
We're going to get 101 through 111.
403, but we need to look at that because it's got some some options there.
I don't think it applies, Val. But
Because
403,
Because there's not, hadn't been,
it's
I
not,
don't think it applies either. I think it's all multiple. I don't think either one of them is.
I mean, there's been a compass.
if Miss Gelly had
You're saying that only
testified,
applies if there's actually a compass testimony?
if Miss Gelly had testified, then 403 or 402 would have been applicable.
Right. But that, you're saying that only applies if if an accomplice actually testifies, not
Right.
if there's testimony about somebody being an accomplice.
That's right.
I don't think that's so much, if one of three co-defendants gets up and testifies and implicates another, then the fact that you can't convict on the testimony of a co-defendant alone or an accomplice.
Or if Miss Gelly had testified, then it would have applied.
That's what I.
But when you don't have an accomplice or co-defendant testifying against the other, then you don't have it.
Well, I'll see you all in the morning.
Just a minute.
Your Honor, can the officers go ahead and start getting collected?
Yeah.
Yeah, that's fine.
Because I think it's fine. We're not closing the door on any argument or any instruction on it.
Well, no, but I mean, I think we've done most of it, but,
If we miss something before those,
well, sure.
sure.
Judge, I've got one housekeeping matter. Judge, I just wonder, as far as the arguments in the morning, obviously the jury instructions, and then in the state's first argument, then one defendant, and then ready for lunch, and then,
Well, I don't know, it just depends on where we are on time.
I mean, you in Jesse's case, you argued an hour. So take 20, 30 minutes to read the instructions. An hour for one guy, then probably a break. And then maybe another hour for the other one, and then a break. And we can work through going up.
In this case, I probably argued about 20 minutes, and the evidence is so clear.
Well, that's okay, we may all get done.
It's 11 on a 10 scale, I mean, my lord, you don't need.
Can you state that on the record?
All right.
John, you might pull the call y'all together.
You know what? Now you done forgot he asked.
You know what I would have said.
Oh, yeah.
You get somebody your own.
He's already forgot about it.
Is that rolling now? In your closing argument, do you anticipate the use of being displayed? Right here.
Probably vertical. Be careful though.
Where do y'all want me in?
John, you got your truck up here.
Can you get over there and that other wicket box on the other side, set up inside that box? Right here? What about here?
In this case, I would be surprised.
What was laying right at here?
It wasn't necessarily because of what it was.
I don't know. I'll see y'all tomorrow.
I just so I was just weird. The combination of everything. Well, that's just you said. I wouldn't be surprised if you were I wouldn't be.
I got the IS meeting for a while.
He worked on when I asked him at the major cases, he worked on the weapons. He's like Charlie, believe it or not, Lynch is a highly respected. You know, one thing we didn't bring up, he's not a member of the
How you doing?
fringes and everything. Everything killed it. I just couldn't wait to sit there. He said, everybody's a member of those things.
I believe the money's better.
That's what talking about. Oh, really? I believe it really true. Kilburn said so. He understand.
I thought we're through. I thought we're through.
What's down the floor?
There's a chance. I thought they were
talking about what's to do. I'm not.
You didn't know what I need to say.
I said this to me.